I'm Brad Edwards. Thank you for streaming with us. Normally, judge races don't get a lot of attention, but you're hearing a lot about the Supreme Court races here in Illinois. That's because there are 2 open seats. The balance of power could shift. 2 open seats, and right now Democrats have a slight 4-3 majority on that court. 4 candidates vying for 2 crucial openings, all right here on the stream. We wanted to help you make a better educated decision when you vote, so we talked extensively with all 4. Then, our take from our friend of the stream and legal analyst Irv Miller. First, the 4 candidates. Justice Mike Burke, who is currently on the Supreme Court, appointed in 2020 to fill a vacancy and now seeking a full 10-year term. He's a Republican from DuPage County in the minority on the court. The court is now 4-3, leaning to the Democrats. Justice Burke, thank you for joining us. First question out of the gate.
So happy to be here. Thank you.
Yeah. First question out of the gate. Why retain you, and why is it this year in particularly is it so important?
Well, I think every seat on the Illinois Supreme Court is important. And why retain me? I think that the voters really need to know, first and foremost, that I'm not a politician, never have been. I'm a judge. I've been a judge for 30 years, served at every level of the judiciary. I've been an associate judge, circuit court judge, appellate court justice, and now for the last 2 years sitting on the Illinois Supreme Court. I started my career as a prosecutor and worked in the trial courts in DuPage County, trying hundreds of cases, and then went on the bench in DuPage County where I served in the trial court for 16 years. And 12 years on the appellate court, and now in the Supreme Court. So I think why choose me? It's really when you're looking at a judicial race and you're a voter, you have to educate yourself. Nobody knows about us. Nobody knows about the judges. We're at the bottom of the ballot, and it really takes some effort for the voters to educate themselves. And really, I think you should be looking for 3 things: experience, independence, and judicial leadership. I think I provide those things.
Where do you stand on privacy? It's a broad question, but some think it seems to be under attack. Women have obviously lost their right to choose in many states in what was settled law, by all accounts, Roe. The thought is, what's next? Gay rights, you can go down the line. Where do you stand on privacy vis-a-vis government staying in or out of the lives of otherwise law-abiding citizens?
Well, I mean, that's a broad policy question that really takes into account cases that might come before the court. I mean, you raised the Roe and Dobbs issue, as well as other issues. So I can't really comment on my personal beliefs on those things. But I do. I mean, I understand the position certainly of the dissent in the Dobbs case, that this was settled law. It was settled law for 50 years, and the Supreme Court sent it back to the states. But again, the Supreme Court sent this issue back to the state legislatures, where the Supreme Court, the majority of the Supreme Court, believed it resides. We have to remember that before 1973, the state legislatures were the place where both abortion and every other privacy interest was dictated. And it's back in the bailiwick of the state legislatures. Our legislature has spoken on that particular issue. In 2019, the Reproductive Health Act was passed and signed by the governor. So that law could change. But I can't make any general pronouncement on whether privacy in general is under attack. All I can do is read the cases and tell you what those cases say. And I will tell you that the Dobbs case the majority of the Dobbs was very specific in stating that it has to do with Roe and not Obergefell and some of the other cases that you've alluded to. So again, there was a special concurrence that went further, but no justice joined that special concurrence by Clarence Thomas. So I'm not going to speak. I can't speak broadly to those policy issues, but again, we take it on a case-by-case basis as to how it comes before the court.
Yeah, but then you say it's kicked to the House of Representatives, on the state level, but then ultimately those things end up in front of the Illinois Supreme Court. So flatly, flatly, abortion, by legal definition, it is settled law. Legal bedrock in Illinois. Women here have the right to choose. I'm not asking you, are you pro-choice or pro-life? I'm asking you, do you respect that that issue is settled law, meaning that right is not to be trifled with? Yes, settled law, or no?
The law in the state of Illinois is that a woman has a fundamental statutory right to choose to have an abortion. That is what the law says right now. You know, I always tell people when I talk to different groups, if you don't like the law, then it's up to you to vote in different legislators who will change that law, who will promise you that they'll work to change that law. Don't look to the judges to rewrite laws. That's not our job. Our job is to interpret the laws, but it's not to rewrite the laws. I mean, I believe very strongly in following both the Illinois and the United States constitutions. Bedrock principle in those constitutions is the separation of powers. The legislature passes the laws. We interpret the laws. So to answer your question, that's what the law is now. Could a future legislature come in and change that law? Certainly.
Justice Mike Burke, we appreciate your candor, and good luck come November.
Thank you so much.
Also running for Supreme Court, the Appellate Court Justice Mary Kay O'Brien, a Democrat. You have served on the Appellate Court for nearly 2 decades, hearing more than 4,500 cases by your own count. Justice O'Brien, thank you for joining us. We appreciate joining us on the stream. What do you think should bring you to the High Court?
Well, Brad, 2 years ago, I would have never thought that the opportunity would arise. These seats on the Supreme Court are pretty generational, and it had been 22 years since there had been an election, but Justice Kilbride from the 3rd District was unseated for the first time in Illinois history. We had a Supreme Court judge that was not retained. And I had to take a look at, my qualifications, all of the different things that I had done, the time that I've spent on the bench, as well as my legal career before that, which included time in the General Assembly. And I thought, I have a depth and breadth of experience that I think makes me uniquely qualified. I've run a small business. I've had my own law practice. And so I've had to manage employees. I have, done family law and consumer law and, banking and transactional things. And then in the General Assembly, I was able to work in some of the largest areas of our statutes. I rewrote the state's grain insurance code. I worked on, child support enforcement, and, I chaired the criminal law committee, and we did death penalty reform, and I worked tirelessly to expand the statute of limitations for child sex offenders. And I was proud that I was also able to make major changes to our generic drug laws, which, Illinois was pretty archaic, and patents would expire, and yet Illinois residents still could not take advantage of cost savings for lower priced generic drugs. So I feel like I have had an awful lot of experience understanding the administrative roles of the court, understanding the budget process. I was on the audit commission, and I think that makes me uniquely qualified to serve on the court.
And where do you stand on privacy? This is a broad question, but some think it in some ways might be under attack, privacy. Women have lost their right to choose in many states in what was, again, considered settled law, Roe. The thought is, what's next to go? Is it gay rights? And go on down the line. Where do you stand on privacy vis-a-vis government staying out of the lives of otherwise law-abiding citizens?
I think the framers of our U.S. Constitution really, they had come here and suffered a lot of tyranny and felt that the government had intruded significantly in their lives, and that it was one of the reasons that they, wanted to escape to a new country. And, the Illinois Constitution does enumerate the right to privacy. And of course, because cases are pending currently, all I can say to you is that we, in Illinois have a heightened regard for privacy, and it is specifically, in our Constitution.
Respect that answer. Justice O'Brien, one final question. Flatly, abortion, by legal definition, it is settled law. It's bedrock in Illinois. Women here have the right to choose. I'm not asking if you're pro-choice or pro-life. I'm asking, do you respect that that issue is settled law, meaning that right is not to be trifled with? Yes, settled law, or no?
Well, it is currently the law in Illinois. Of course, with the Dobbs decision, sending everything back to the states to be determined, there will be and are currently lawsuits that are filed, and you don't know the nature of the challenge to the statutes until you actually see the cases play out in court.
Justice Mary Kay O'Brien, we appreciate your time on the stream. Enlightening conversation, and good luck in November.
Thank you. Thanks for your time. I appreciate it.
Now, to Judge Elizabeth Rochford, a Democrat who's been on the bench in North Suburban Lake County for a decade. Judge Rochford, thank you for joining us on the stream. You're running a commercial now that aims to highlight two differences between you and your opponent. Explain.
So the thing that distinguishes me is experience, leadership, and service. And my opponent has never been a judge and has been found not recommended by all of the bar associations who are nonpartisan evaluators of candidates for the Illinois Supreme Court. And when I was evaluated by all of the bar associations, I received the highest rating, highly qualified and highly recommended by all three reviewing bar associations. And I think that's a significant difference in our candidacies.
Judge, where do you stand on privacy? That's a really broad question, but some think it seems to be under attack. Women have lost their right to choose in many states. That was considered settled law, Roe. The thought is what's going to go next? Gay rights, and you go on down the line. Where do you stand on privacy vis-a-vis government staying in or out of the lives of otherwise law-abiding citizens?
So again, the canons of ethics, for judicial ethics, require a judge to not ever commit or even appear to commit to an outcome in a case. So, but what I can say is that I commit to the voters and everyone in the state of Illinois that I will continue to hear cases as they come, consider all of the facts and evidence, and then follow the rule of law and the established precedent. But beyond that, I really can't guess how I might rule on a particular issue or a particular case. When you put that black robe on, you hear the case that comes before you, and I'm always reminded of that beautiful phrase on the back wall of the Illinois Supreme Court that the justices look at, audi alterum partem, which is a Latin phrase and translates to hear the other side. And that is a judge's responsibility and role, and I commit to you that that is what I would perform as a Supreme Court justice, as I have historically as a judge in circuit court.
Flatly now, abortion. By legal definition, it is settled law, bedrock in Illinois. Women here have the right to choose. Now, I'm not asking, are you pro-life or pro-choice? I'm asking, do you respect that the issue is settled law, meaning that right is not to be trifled with? Yes, settled law, or no?
I respect the law as it stands here in Illinois currently, and will continue to uphold it, and that's the law, and that's what I'm bound to follow.
Judge Elizabeth Rochford, candidate, Democrat, 2nd District, we appreciate you joining us, enlightening conversation, and we appreciate your candor. Good luck come November.
Thank you so much. So grateful for your interest in this important race.
And joining us now, candidate for Illinois Supreme Court, 2nd District, Mark Curran. He's got a long resume, former Lake County Sheriff, former prosecutor, professor of constitutional law, Democrat turned Republican, that you're the only candidate, Mr. Curran, without any judicial experience. What makes you think you're ready to jump right into the big leagues?
I've taught constitutional law. I understand the Illinois Constitution. I understand the U.S. Constitution. Essentially, that's what you're doing, is applying the facts to the law in resolving the issue. And that's something that I've done for a long time, and more than qualified to do so.
Obviously, we know the legislature passes laws. You will be there kind of as a final stop when it comes to that. But this next question kind of falls under that. Again, it's not exactly your purview. But where do you stand on privacy? This is a broad one, but it seems something to be under attack. Women have lost their right to choose in many states via what some considered settled law, Roe. The thought is what's next to go. Gay rights, go on down the line. Where do you stand on privacy vis-a-vis staying out of the lives of otherwise law-abiding citizens?
So yeah, I agree with that concept, generally speaking. And, Roe versus Wade, I think the basis for that decision essentially was that it needs to be a states' rights issue. When we look at the 10th Amendment, those powers not expressly stated in the Constitution are reserved for the states. So it becomes a states' rights issue. Illinois has drafted legislation regarding abortion because they have that right to do so. There's nothing in there that appears to lend itself to anything that Justice Burke or myself could ever do anything about. So it's a legislative issue, and as far as other groups out there, obviously I respect their right to a privacy and privacy in their own homes as well.
Yeah. So
limited government.
Okay, limited government. So finally, just flatly, on abortion. Not asking are you pro-choice, pro-life. I know you can't get into those things because of, the canons of the court, so on and so forth. But, do you believe that a woman's right to choose in Illinois, as of right now, is settled law, meaning that it's something and a right not to be trifled with as the law stands now? Do you believe it is settled law in Illinois, yes or no?
Yes, I believe it is settled law. I don't see any basis for which, at this point, it can be changed, nor will it be changed.
Former Sheriff Mark Curran and Supreme Court judicial candidate, we appreciate the conversation today. Enlightening. Good luck in November, and thank you for joining us on the stream.
Thanks, Brad. I appreciate your having me.
A lot to digest there, and the race is a biggie. Right now, the balance of power for the Democrats. The Illinois Supreme Court, 4-3. 4 Democrats, 3 Republicans, 2 open seats. So the balance of power is up in the air. It is a critically important race. 2 races, and when we have critically important legal issues, we bring in one man. Friend of the stream and our legal analyst, chief legal analyst, Irv Miller. Irv Miller, why don't you break down the 2 races as simply as you can for me?
Well, the 2 races are not involving Cook County. They're involving counties outside the state, outside of Cook County, the 2nd Supreme Court District and the 3rd Court District. And right now, as you know, we have a balance of 4-3 Democrats over Republicans. And with the outcome of these 2 races, it can either stay the same, depending on who wins, or it could flip over to 4 Republicans and 3 Democrats. So these 2 races are actually crucial with respect to what the Supreme Court of the state of Illinois may be deciding in the future.
Okay, let's look at it race by race. One race, you have former prosecutor, former Lake County Sheriff Mark Curran, Democrat turned Republican, facing Democrat Elizabeth Rochford, currently serves as a circuit court judge in Lake County. How do you see that one shaking out?
Well, you have a highly qualified recommended candidate by the various bar associations, which is Elizabeth Rochford, and a candidate that's not recommended by bar associations, which is Mark Curran. You also have a candidate that's been a judge for a long time, again, Ms. Rochford, and you have a candidate that's never been on the bench and wants to start off his judicial career on the Illinois Supreme Court. So with respect to qualifications and endorsements, I think you have to say that you're looking at qualifications. It's an easy decision. The other issue on any race is issues, and they obviously will have different issues, different perspectives on the law. And if you think that the Republican candidate will have ideas on the court that the Democratic candidate may not, that may tip the balance in favor of the Republican candidate. So I think you have to take qualifications compared to potential issues and make up your mind as far as which type of candidate you want sitting on the Illinois Supreme Court.
The other race, incumbent Republican Supreme Court Justice Michael Burke facing a challenge from Appellate Court Justice Mary Kay O'Brien, a Democrat. Tell me about that one.
You know, you have two experienced judges. Right now, Justice Burke sits on the Illinois Supreme Court. He wants to stay there. You have Mary Kay O'Brien, who's been a judge for a long time. They both have tremendous judicial experience. They both rated well by bar associations. And again, it's a question of, okay, this time it's not a matter of who's qualified. They're both qualified, but the issues behind them as to what their beliefs are on various issues and how they're going to put their personal or professional beliefs in court opinions in the future based on some pretty serious issues, including rights to privacy and also perhaps the Second Amendment, which is also a potential area that could come before the Illinois Supreme Court again.
You saw our 4 interviews. We've got each of the candidates, Republican and Democrat, Republican and Democrat. Any key takeaways from the interviews you saw?
You know, the key takeaway is they're both, in both races, that all 4 of the candidates are finally abiding by the Illinois Code of Judicial Conduct. They're not trying to tip their hand as to what their views are on any particular decision that may come by in the future. They basically stayed the course, trying to keep a nice neutral stand, trying to say, hey, Illinois is settled right now. At least that was one of the candidates' positions. The other candidates basically agreeing that abortion is in fact settled law. The rights of privacy are settled, and they should recognize that because frankly the right of privacy is in the Illinois Constitution, where in the United States Constitution that does not appear and was only determined to be there by the Supreme Court of Roe versus Wade, which was recently overturned by Dobbs. So there's issues there that you may want to look behind what these justices candidates are saying to determine what their positions may be in the future. Because the Illinois legislature can always change the law. Right now, it's clear that Illinois, take an issue of abortion, right now the law is clear in Illinois, but that could be subject to a vote by the Illinois legislature that could actually change that in the future.
So all the interviewees, all of the candidates really abided by the canons when it comes to what they could and could not say. An issue you brought up, an important one, though, is not necessarily what came out of their mouths, but their advertising. Maybe not even advertising they paid for, but advertising that's paid for on their behalf. PAC money, dark money, somebody else's money. You had some serious questions as to whether any of the advertising violated the Illinois Code of Judicial Conduct. Do you still have those questions?
You know, I do. You know, it's okay for a candidate for the Supreme Court to be endorsed by groups, law enforcement groups, political groups, whatever. It's okay for them to be endorsed by Planned Parenthood even. But when you say in your advertising, I have been endorsed by Planned Parenthood, and I am qualified by the Bar Association, and having just those 2 in your ad, you're basically saying that you are in favor of abortion rights, and you will rule that way if in fact a case comes before you on the Supreme Court. I have troubles with that as far as whether or not that complies with the Code of Judicial Conduct of the state of Illinois.
There were a number of ads you had questions about, one in particular. Let's take a look at that one.
Mark Curran, thanks for coming in. You're here for the Supreme Court position, but you've never been a judge. And the Illinois State Bar says you're not recommended. Let's see your references. Illinois Right to Life calls you the most pro-life candidate. We'll be in touch.
With over 10 years as a judge, Elizabeth Rochford will protect our rights. She's rated highly recommended by the Illinois Bar Association and endorsed by Planned Parenthood. Elizabeth Rochford for Supreme Court.
Tell me why that ad in particular may have crossed the line.
The ad says endorsed by Planned Parenthood. Planned Parenthood is a group, obviously, that favors abortion rights. When a candidate for the Illinois Supreme Court is saying, I've been endorsed by Planned Parenthood, they're adopting the opinion of Planned Parenthood. And that is expressing an opinion on an issue that may come before the court in the future. And that's what the Code of Judicial Conduct says is not right.
This is really in the weeds. It's probably an argument for another day. We have politicized these races for the Supreme Court, which you believe, I would imagine, should not be politicized, correct?
You know, I don't believe that judges should be running in political elections. I don't believe that judges should be subject to having to run for office and accept cash donations to run for office in a partisan election. I think the public has a right to know when you're running for an office what your positions are. And when you're running as a judge, you're prohibited from letting people know what your positions are because it's unethical. So if you're prohibited from letting the public know where you stand on issues, it's really not a legitimate election because you're just saying, hey, listen, my name is so-and-so, and I think you should vote for me. And this is not a candidate you see for public office in a legislative body or a local election to run for mayor or whatever, where you express your opinions. These candidates are not allowed to express their opinions on issues, and that is just not right.
When all the dust settles in November, right now, there's a 4-3 majority for Democrats on the Illinois Supreme Court. Do you see that changing?
Based upon the recommendations of the Illinois State Bar Association and their recommendations, if their recommendations come to be based on the voters' choices, I suspect it will remain 4 Democrats and 3 Republicans.
Still very close. And there was a pause in that answer. Irv Miller, our legal expert, thank you. And if he pauses, that means it's probably going to be a close one. It's important to note that not all of us will get to vote for the Supreme Court. Only voters in Districts 2 and 3 on this map will cast ballots for a justice of their choice. Those are the 2 areas where there are the openings. So if you live in the gray, blue, and or the pink area, you will be voting for a Supreme Court justice for your district. I'm Brad Edwards. Thanks for streaming with us.